While searching for information, do you keep finding lawyers who are just selling their services instead of answering your questions? With 24 years of experience, I'm familiar with the frustrations you may have while making an injury claim through an auto insurance company. I do my best to actually answer your questions in these videos and in my free book. I am Arizona native and attorney Kevin Fine, and in this video I answer your questions about what a mediation is and how you might use one. If your auto injury claim is in litigation, once discovery is complete, both you and the insurance company may have changed your positions on what the case is worth. That means you will probably want to negotiate in earnest again to see if a resolution can be reached. A popular way to formalize the negotiation at this stage is to use a professional mediator. They are usually very experienced attorneys, so they are not cheap, but neither is going all the way to trial. If you decide to mediate, then the mediator will work with you and opposing counsel to set a time and a place to hold the mediation. The mediator will ask for a memorandum from each side that explains its position, which can either be kept confidential from the other side or both sides can decide to share it. There are no set requirements for what a mediation memorandum should contain, unless the mediator specifies some guidelines. That means they can vary greatly in content and style. The mediator will also need some of the most important documents to review, so include these as exhibits to the memorandum, a lot of the documents you've used in litigation. On the day of the mediation, the mediator may bring everyone together briefly at the beginning to explain the ground rules and procedure, and then put you and the opposing side, usually the defense lawyer and the adjuster, not the defendant, in different rooms. Then throughout the mediation, the mediator will go back and forth discussing the strengths and weaknesses of each side of the case, sharing thoughts on the case value, etc., to see if the mediator can bring the parties to an agreement. The mediator does not decide the case and cannot force anyone to do anything, including that the sides come to an agreement. If no agreement is reached, then nothing happens in the mediation that is binding on anyone afterward. Nevertheless, mediations are often helpful in reaching an agreement. If the mediation works to reach an agreement, this case is over. If not, you continue to prepare for trial. I answer more of your questions in my other videos, articles on my firm's website, and in my free book. Because your situation will be different in significant ways, the general information I presented here may not be right for your matter and is not legal advice. If you wish to talk to me about your concerns more specifically, I do offer a free consultation. You can set up that visit or you can order the free book through the contact information on the banner below.